Well, hello and welcome everyone to another session in the Solid Finances series. I'm glad you could join us today. Before we get started, just a few reminders. First of all, I want to thank our hosts, the Finner Investor Education Foundation, Montana State University Extension, North Dakota State University Extension, South Dakota State University Extension, and the University of Idaho Extension have all collaborated to bring this program to you today. Please visit our website. We do keep our upcoming schedule there. We also have recordings of all of our past information, all of our past sessions. And if you have a question, we'd really like to hear from you. And our email addresses are always posted there, and our phone contact information as well. So I'd encourage you, if you haven't bookmarked that site, to go ahead and do that. And we'd love to hear from you about ideas for future sessions, questions, things like that that we could help you with. We do want today's webinar to be as interactive as possible, so if you have questions or comments or clarifications you'd like to have, please send us a question in the question and answer pod at the bottom of the screen. It does come to us anonymously, so if you send in a question, we'll just say we've had a question come in, and then we'll address that to the presenter so it can be answered, so you don't have to give your name out to everyone on today to have your question submitted. And then we will have a collection of polls today where we'll give you a choice to give a multiple choice answer on a particular question that'll come in. So please participate in those. Helps it be a little bit more interactive today. And again, those are anonymous as well. So please utilize both of those tools today. Just a reminder, we have 2 more sessions left this year. March 22nd, Karen Ritchell from the University of Idaho Extension is going to present Who Gets Grandma's Yellow Pipeline in Idaho. Many estate planning rules are state specific, so that March 22nd one is going to focus on some rules that are specific to Idaho. Now on March 29th, our last session for this year, Lyle Hansen will be presenting, and he's going to talk about working with investment professionals, and that also says in Idaho. However, about 99% of that session will be valuable to everyone. Very little of that will be state specific. So we do have that labeled as an Idaho session, but I think it's going to be generally applicable to everybody. So please mark your calendars for those 2, and that will wrap up our spring series. So today we're going to have Marcia Getting join us for the second week in a row, and she's going to share some estate planning things, and also she's going to link those into some pretty wonderful wildflower photography. So with that, I'm going to turn it over to Marcia.
Okay, Joel, thank you very much. I'm delighted to have the opportunity to share some information with you and focus on the wildflowers. Now, you might think that that's kind of a weird thing to talk about wildflowers, but I'd like for you to think of these as triggers. That maybe you can associate a wildflower with a strategy that I might mention that will make the whole process a little bit easier. And of course, if we can make that less expensive, people really appreciate that. So the first poll that I'm going to do today is just get a sense of the audience. I'd like to know if you're married with children, and here I'm not talking about minor children. I'm just saying, do you have any children? And they don't have to be located in Montana, or they could be anywhere. Are you married without children? Are you single with children and single without children? The reason I do this is I'd like to make sure that the examples I plan on are going to apply, and then I can adjust those just a little bit differently if I need to. So it looks like you're a pretty typical audience with 75% of you with children, and we've got some single folks without children as well. My second poll is very quick. When did you last review your estate plan? Is it that you don't have one? Be honest. Remember, we won't know that's you. Was it the past year, 2 to 5 years ago, 6 to 10, or more than 10 years ago? And I think the record for this is somebody who indicated theirs was done in 1965. Okay, amazingly enough, my goodness, you are what I would call one of my typical audiences. You're saying that you don't have one. Almost 70% of you said that in the beginning. So what I'm going to do then is use my steer's head. And what I want to do is steer you towards an awareness of Montana's plan. Because you 70% that don't have one, oh yes you do. And it's the state of Montana's plan. The legislature has said we've got these people, and typically 7 out of 10 die without writing a will. So we need to decide where the property's going. And then I also want to steer you towards some estate planning tools that you can walk right out of here today and be able to use. So let's take a look at the bitterroot. This is our Montana state flower, but what that reminds me of is the bitterness that can result in families from lack of planning. If you're one of those that are going to let Montana law decide how your property is going to be distributed, you need to be aware that 85% of the people that I've been working with indicated that law would not distribute property the same way they would. And oh, as an aside, when you see a black box, what that denotes is the person or persons are deceased. And you can see what I mean in this particular slide. Now you're going to think it's a little bit busy. And if we weren't using Connect, I would be able to zoom in just one of these at a time. But let me tell you what it is that happens. This is a family that we've got the husband and the wife, and then we've got the next generation of 2 sons and a daughter, and then we've got all the grandchildren. Now what happened is the son passed away in 1999 as a result of an airplane crash. We had the daughter pass away in 2005 because she was killed in an accident in eastern Montana. Well, the next thing that happened is the husband passed away. So the last one that passed away was mom, his wife, the grandma, the mom, and she didn't write a will. So since she didn't write a will, she's under Montana's plan. And being under Montana's plan, I want to know what you think the state of Montana is going to give to the grandchild D there that I have marked with the red lightning bolt. So these are your choices. Okay? Is Montana going to give that child nothing, 1/6 of the estate, 1/7 of the estate, or 1/9? So remember, this is your opportunity to be a legislator and indicate how you think the property should be divided. All right, we've got a lot of people participating today, and they're coming in. We're at the end, and what we've got is 46% or 41% that said 1/9. But we also had 41 that said nothing. Now let's take a look at this. This is the way Montana divided the property. So all of you that said 1/9, you are quite correct. And you may be sitting there saying, now wait a minute. Those of you that didn't respond to that one, why is the answer 1/9? Well, Montana uses a concept that's called right of representation. You can see that up there in the yellow box. Now, what does exactly that mean? Well, if we take a look at the second generation, we have 2 sons and a daughter. That means mom and dad had 3 kids. So that indicates to us that the property is going to be divided 1/3, 1/3, and 1/3, but it depends on the circumstances. So we do have a son here that had a child, and that child here is receiving 1/3. And the reason he receives 1/3 is his parent was deceased. So you see, the property doesn't go to the wife. What it does is it goes to the child. Now, this son up here in the yellow box receives 1/3. And the reason his 2 kids don't receive anything is that he received the 1/3. And then the question that I ask you is this child here, and he receives 1/9. And so do the other 2. And the reason that we see 1/9 is 1/3 of 1/3 is 1/9. So that's how the state of Montana divides the property using the concept right of representation. So I would like to recommend that you draw your family tree and X out people. If nobody's passed away yet, experiment and see what would happen to the property for those almost 70% of you that died without writing, or well, could die without writing a will. So this is my reflection from the Bitterroot, is that parents and grandparents need to decide if right of representation, right of representation is what you want to apply to your family. And those of you that are sitting there very smug because you already have a will, I would encourage you to take a look at that will and see, does it say in there right of representation? And if so, did the attorney explain that to you and you know the real effect on your family? Now I'd like to introduce the family of larkspurs. And when I was out doing a presentation, I had one lady that really knew her flowers. And what she said is, Marcia, do you know how toxic these flowers are? And I thought, super. What I'm going to do is use that to talk about toxic family relationships. So here I have a brother that I'm indicating is deceased, okay, because he's got the black on him. And what we want to know is, of these relatives, he has mom and dad, he has sisters and brothers, and he has nieces and nephews. What group has priority when this brother dies without writing a will? Is it going to be the parents? Is it going to be brothers and sisters? Or is it going to be the nephews? Who has priority? Okay, sounds like I didn't really fool too many people here with this question, because 80% of you are saying it's mom and dad, and you are quite correct. They are going to split the $4 million ranch that this brother had, and it's going to go half to mom and half to dad. And of course, if we only had one of the parents alive, that parent would receive it all. Now, if the parents are deceased, then true, it would be the brothers and sisters. And what the brothers and sisters would do is inherit equally. So there's 4 of them, so that means 1/4, 1/4, 1/4, and 1/4. So what we've got here is the state of Montana saying there is going to be an equal or a per capita division, not right of representation. So I've got a question for you. You see that I have a red lightning bolt on one of the brothers. And you see what happened is we actually had one of the sisters die in 2001. We had another sister pass away in 2005. And then the brother died later. He died in 2011. So the red lightning bolt brother, I want to know what fraction, if any, will that brother receive? Will that brother receive all of the estate? How about 1/2? How about 1/4? Or, since he's single and he didn't write a will it all pass to the state of Montana? Wow. You know, this is the part that always depresses me, because what I'm discovering is that about 61% plus missed this question. See, I was testing you to see what you learned about right of representation. And that applies in this example just like it did on the other one. You see, we've got 2 brothers that are living, but we can't forget about the sisters' nephews here, or the other sister's niece. So the first thing we would do is count the number of siblings. 1, 2, 3, 4. So that means 1/4 is going to go out. And that's why the brother got 1/4, the other brother got 1/4. But here's the niece. She moved away from Montana 20 years ago, and she hasn't had anything to do with her Montana relatives. And these 2 nephews, well, it's embarrassing. One has been arrested for drug dealing, and the other one we don't even want to talk about. So you see, this is another example of right of representation. And I wish I could have sat down with this bachelor brother and said, hey, draw your family tree, and you can see where your property's going. Because everybody said he didn't have any respect for his nieces and nephews, but yet they inherited part of his estate. So he really did need to do some planning. Now, if the situation had changed, you see we use the concept of right of representation again. And we've got 4 kids, okay, or siblings in this case. So it's 1/4, 1/4, and 1/4. But because this one sister was deceased, then what happens with her share is it goes down to the niece of this brother. So again, the importance of drawing your own family tree and getting a sense of where your property's going is a really good family exercise. That can get the conversation going. Now, it could have been the brother would have written a will, and maybe he would have left all of his property to his favorite nonprofit organization like the Montana 4-H Foundation. So I need single folks to take action as well. You need to decide if you want to pass your property by right of representation, or are you going to write a will and do it differently? Because in doing so, I think you could avoid some toxic family relationships. Now, this particular flower is a prickly poppy that we found in Utah. And what that makes me think about is how we title property. And sometimes that can be a little prickly, or the result could be prickly. Let me show you what I mean. After you tell me how the majority of your property is owned. Is it in sole ownership? Is it in joint tenancy with right of survivorship? Tenancy in common, in a trust, or is it one of those business type approaches? Well, it appears that you are another typical audience in the sense of how you've titled property. We've got 50% that have theirs is joint tenancy with right of survivorship, and that's what I find across the state. I find very few people that know anything about a tenancy in common. So my action for you is to look for sure and see how your real and personal property are titled. That includes your checking account, savings account, certificates of deposit, etc. So since many of you have joint tenancies, I'm going to look at a joint tenancy between parents and children and couples. So let's look first of all at a parent. Here we've got a mom, and what she's done is put her $80,000 checking account with her daughter Susan, and this is who she expects to pay the bills, the newspaper, all those kinds of things. And what mom has said is, then I've written this will, and in this will I've divided that $80,000 equally between the three daughters. So the will was written after the joint tenancy was formed. So my question for you is, how is that $80,000 going to be divided? Is it going to be equally, according to mom's will, among the three daughters? Is it all going to Susan because she's the joint tenant? Will it go to Carrie, all to Jane, or will it go to Montana? Well, we've got 78% of you that say yes, it will go to Susan. And that's true because that's the surviving joint tenant. So you see, those of you that thought a will would undo a joint tenancy are mistaken. In this case, daughter Susan gets the $80,000, Carrie and Jane get $0. Even though mom said, now you will share with them, won't you? So we certainly know what mom's intent is, but it could be daughter Susan is the one that says, look, I am the one that's been paying the bills. You two have lived out of state. I'm the one that mom calls when she needs something. So she justifies, she rationalizes in her mind that she should be the one to keep it. So that's what Montana law says, that when you have joint tenancy with right of survivorship on any of your real and personal property, it's going to take priority over the will, and it doesn't make any difference when that will was written. Now, if we have a situation like this, what we need to know is that Montana has provided us with a tool, and that is the Multiple Party Accounts Act form. And that allows us to make an agency designation on our accounts, and we can make as many account transactions as we want to, but we don't have ownership rights. So this is just an example of part of the form. So if, for example, mom didn't want Susan to have ownership rights, she would have checked the multiple party account without right of survivorship. This means Susan would be able to write checks up until Mom's death, but then at that point, the $80,000 goes into the estate, and in this case, Susan, Carrie, and Jane are all going to split equally. So they each get $27,667. The Mont guide that we have that explains this in more detail is called Non-Probate Transfers. It provides an example of the Uniform Multiple Party Account Act, and there's additional resources there for you. And this one is on your resource list. So my reflection from the pink monkey flowers is use the Montana Multiple Accounts Act form when it's appropriate for your individual situation. Now, I want to look at another kind of joint tenancy, but this is white mule's ear. And what that makes me think about is Dad. I want to examine the consequences of Dad being stubborn as a mule. Now, I'm sure none of your dads are this way, but mine had tendencies towards that. And here's a life change. I'm saying that Dad the mule remarried in 2010. His wife had died earlier, and what he did was place property in joint tenancy with his new wife. Then he wrote a will, and he said, I'm going to leave you kids the ranch. So do Dad's kids get the ranch? Yes or no? No, no, no. 90% of you are right. No. Dad's kids don't get the ranch. Remember, the property is in joint tenancy with his new wife. And no wonder child A is the one that's been calling me, wanting me to talk to their stubborn as a mule dad. And I can't do that. What I can say is, gee, I'm going to be doing a program in Glasgow in March. Bring your dad there and he'll learn. But you can imagine why the kids are upset, is they thought they were going to get the ranch. And in this case, they won't, because the joint tenancy takes priority. Now, I'm going to say that several years pass. And what happens is that the new wife dies with all the property in her name. Now who's going to inherit that property? Well, of course, it's her two kids, and they split equally. Now you can imagine his two kids, how they feel now. You know, I've had some say, well, I would sue. Well, good luck, because it's not going to do you any good. And I actually had another similar situation like this, where this new wife remarried. And would you believe she placed the property in joint tenancy with her new husband? She died as a result of a car accident. Who got the property? The new husband. So in this particular case, not only were his kids disinherited, but hers were too, by the way the property's titled. We have too many people in Montana think that you can do a will and undo the joint tenancy. And that is totally false. So you need to be aware if your folks have come along and said, well, hey, Robbie, could we put your name on our safe deposit box? Can we put your name on our checking account? Hey, Deborah, come on over. We just want you to do that. Well, I would encourage you to think about that twice, because it never fails. The other relatives think that you're doing something wrong. So my mule's ear recommended action is don't be stubborn as a mule. You need to seek legal advice before you're titling property. Unfortunately, most of us haven't done that. But if you're considering remarrying, that is a really good time to look at that and establish a premarital agreement. Now here we have something that was exciting for me to discover this past year was an albino fairy slipper. And then on the right, I'm showing you what that fairy slipper looks like originally. But since I only saw one of those, that makes me think of solely owned property. And I've got solely owned property here with John and Mary. And John and Mary are reaching up in years, and they've told the friends and relatives that they wish to leave their property to the MSU Alumni Foundation. But there's a catch. The property is titled in John's name only. He's what I refer to as that traditional Montana man. So of course you can figure I'm going to have an accident happen, and I'm going to say that John dies immediately, and Mary survives but then dies on the third day. Now John and Mary don't have kids. They don't have a will. So the question becomes, who is going to receive the property that's in John's name? Is it going to be John's relatives, Mary's, half and half, or is it the Alumni
while folks are voting
Foundation?
on that, we had a question come in, and it says, what is the mechanism to place property in joint tenancy?
When you open a bank account, you will just indicate that, John Jones and Mary Jones as joint tenants with right of survivorship and not as tenants in common. The same thing happens with a deed. You've got a deed to real property. You probably also got a loan on that, but you title it, if you want the joint tenancy, in both names, and you follow that with as joint tenants with right of survivorship and not as tenants in common. Okay, we've got a big difference here in your thinking of who is going to get the property that was in John's name. 46% of you are saying John's relatives. But I know what Mary or the others of you are thinking, that you're thinking, well, Mary survived, so therefore, and then she died, it should go to her relatives. Well, here's the deal. Montana has a survival requirement indicating an heir must survive 120 hours or 5 days. Otherwise, the heir is treated as predeceasing the decedent. Don't you just love that legal terminology? So in this case, Mary is treated as predeceasing John. Why? She died on the third day. She did not survive to the fifth. So this is an elderly couple, and I've been visiting with them, and they don't think they need a will. And after I gave this example, John still said, well, I still don't see the need for a will because my relatives get it. And I said, okay, John, here's the deal. What if John dies immediately? That's you. And what if Mary dies 6 days later? Now who do you think's relatives will receive everything? Mary's. Uh-oh, all of a sudden, John is interested in writing a will. So they made an appointment with an attorney to get that will written, and then they wanted to bequest some of their assets to the Montana State University Alumni Foundation. So my reflection from the albino fairy slipper is that married couples with solely owned property must write a will so they can control what assets they leave to relatives and what assets they're going to leave to a nonprofit. Very important to do that thinking. Now, this is a false Solomon seal. How they got that name, I really don't know, but what that triggers me to tell you is your next question is going to be true or false. So here's a husband that has $800,000 in his name. This is an easy one for you. It's in his name only. He has $800,000. Again, no will, no children. And I'm saying the wife receives all $800,000. Is that a true or false statement? So the husband dies with all the property in his name. The wife receives all $800,000. Well, 66% of you are saying that's true. Well, aren't I glad I asked this question? Remember the name of the flower? False. Okay, it's false. Because what Montana does is say we're going to leave the surviving spouse the first $200,000 and then 3/4 of the balance. And that means we leave mom and dad 1/4. So in this case, father and mother are receiving $75,000 each and the wife only $650. So we've got a problem there if the husband wanted his wife to receive everything. Now let's say instead of that property being solely owned, that they put it in joint tenancy between the husband and wife. Now ask yourself how much you think the wife would receive. And I'm sure all of you thought 800,000 because now you know joint tenancy takes priority not over the will, but also the law of intestate succession. Now let's look at this tenancy in common property. It's a really interesting one because it's one that I found hardly anybody has their property title that way. And why, I guess, is my question. But let's look. When you have a tenancy in common, each owns an undivided interest in the property. It means you own 1/2 of the whole thing if there are two people. So if we look at our example that we've got here with the husband and wife, technically he owns half, or we'll just represent that with 400,000, and the wife owns half with 400,000. So when he passes away, we only divide up his share. So we give the first 200,000 and 3/4 of the balance to his wife, and then we give 1/4 of the balance to the parents. So in this case, it means the wife receives 750,000 and father and mother receive only 25,000 apiece. So you see, these are examples that you could share with some of your younger families that have gotten married and they don't have children yet, because how they title that property makes a big difference. Now, it could be the husband would write a will, and in his will, he could leave his share of the tenancy in common property to his wife, and that way she would receive the full 800,000. Or he could write a will and leave his share of the tenancy in common property to his son. So that means then the son and the mother, or in this case, stepmother, would own that property together. So property title really does impact the dollar amounts that an heir would survive. So solely owned, 650, tenancy in common, 750, and joint tenancy, 800,000. So you can see why when people ask me, what's the best way to title my property? Well, number one, I can't give legal advice. And number two, it depends on the circumstances of the family. So my reflection from the false Solomon seal is don't make false assumptions about how you think your property is going to pass. You can find out by using our MSU extension Dying Without a Will website, and that's on your resource list. Now I've got a heart-leafed arnica, and that makes me think of heart-to-heart estate planning. As a matter of fact, I've got Joe Hart and Brooke Hart. And Joe has had these heartfelt intentions. What he's done, he's got a $100,000 life insurance policy, and he's designated Brooke, his sweetheart, as his primary beneficiary. Well, Joe later changes his heartfelt intention, and he writes a will. And now he says, I bequest all my life insurance proceeds to my son, Eric Hart. So you can bet I'm going to ask you a question, aren't I? And that question is going to be, is it Brooke that receives it, or is it Eric? So this is your poll. Who is going to get that $100,000? Is it going to be Brooke, or is it going to be Eric? Because remember, the will was written most recently. All right, we've got 61% that said Brooke and 38 or 30 that said Eric. And those of you that are thinking it's a contract, it is. You see, Brooke is going to get the $100,000. She's the designated beneficiary, not Eric. So what should happen if we want Joe, if he's wanting to make sure that his son receives it, he needs to fill out a new beneficiary designation form, and he needs to send that to the life insurance company after he keeps a copy for himself. So I'd like for you to say this out loud. If you're in an office, you can do that. But put this in your brain. You can't undo a contract with a will. You can't undo any contract with a will. And you need to know how true that is in Montana. So my reflection from the Heartleaf Arnica is have a heart. Review your beneficiary designations on your life insurance policies as well as your individual retirement accounts. Now this particular flower is a mountain death camas, and I'm so embarrassed to say that before I knew what it was, I used it as a get well card. Now, is that tacky or what? But luckily, I had an understanding recipient that knows sometimes Marcia is a bit dingy. So what a death camas makes me think about are pods and TODs. A pod is a payable on death designation that you can place on your financial accounts at your bank, savings bank, or credit union. You can use them for your certificates of deposit as well, and even United States savings bonds. And what that means is that at your death, the ownership passes to the POD beneficiaries that you've named. And there's no probate. All your beneficiary will need is an affidavit that you're dead, and a government-issued photo ID. And they just waltz right in the bank and say, yo, so-and-so has died, here's the affidavit of death. And, you should be at least kind and cry a little, but not just go in there, happy days are here again. You can also have a joint tenancy and a payable on death designation. The wording on the accounts are Barb, like this, Barb and Jack, and it's with right of survivorship. So this is what you could do as parents. And then you could POD it to your children equally. So they're leaving it to Charles and Kathy equally. Now, a transfer on death registration is for our stocks, bonds, and mutual funds. And some of you that have already purchased stocks did a beneficiary designation when you opened them. But now we have this transfer on death registration because they're offering these in Montana, and you can have a TOD. Now, if you transfer on death, the TOD beneficiary makes a decision about the mutual fund stocks and bonds. And they can decide if they're going to keep them or if they're going to sell them. So Joel, let's say that I've made you a TOD beneficiary of $100,000 in stocks that I only paid $1 for. Are you going to keep those or are you going to sell those? Okay, he is going to keep them. And what that means is he gets to step up in basis to $100,000. And if he sells them then, changes his mind and sells them at $100,000, he doesn't have any capital gain to pay. But if he keeps them for a few more years and the value increases up to $150,000, then he only pays a capital gain on the $50,000. So keep that in mind. Those stocks and bonds can pass to your beneficiaries. They don't have to have the TOD on them. The fact that you died means they get a step up in basis. Now, the other thing that you can do with a TOD and a POD is leave your in this case, your stocks and bonds, your checking account, etc., to charities or nonprofits. So that could be the Montana Community Foundation, the MSU Alumni Foundation, or the Montana 4-H Foundation. So my reflection from the Death Canvas is use your pods and TODs because you can control your property distribution after you die. You don't need a will to do that part of it. And you can avoid probate fees on this because probate fees are based on the value that passes through the estate. Now that you know about pods and TODs, will you place them on your accounts? Great, we have 40% that already have them and the other 60 get to your bank, etc. right away. Now I want to do an explorer's gentian. It's a beautiful flower because I want to explore a beneficiary deed with you. And this is a way you can convey real property to what are called grantee beneficiaries And you can do this upon death without cost of probate. And this is only effective upon your death. They can't use your property for collateral. The grantee beneficiary can't sell it out from under you. It's still your property. You're just saying, when I'm gone, I want it to go to these people. So you file a beneficiary deed with the clerk and recorder in the Montana county where the property is located. So I'm talking here about a Montana law. If you own property in another state, you have to find out if they have a beneficiary deed. And who can be your grantee beneficiaries? Actually, anybody that you want to. Spouse, children, relatives, friends, corporation, and good old charitable organizations and nonprofits again. So I didn't think I'd live to see the day that the Montana legislature would let us pass our real property by this method. It's great. Now, my foxglove reminds me to tell you that you need to outfox the law if the grantee beneficiary dies before you do. You know, that's bad planning, but here you wanted so-and-so to inherit it, and they died before you. So what you can do is be foxy and specify a successor. So that's what Mark has done. He's saying, if something happens to me, I want it to go to Evan. But if Evan dies before I do, or in the same car accident, whatever, it goes to Luke. You can also do a nonprofit. Well, my goodness, how did MSU Extension get in there? Somebody's probably been messing with my slides. So my reflection for the foxglove: outfox the law and name a successor grantee beneficiary. Now, how about a blue flax? Well, this makes me think of Gary Blue and Linda Blue and his son Matt Blue. And what Gary has done is he filed a beneficiary deed naming his daughter Linda as the grantee beneficiary. Well, later he changes his mind. And what he's done is write a will, and he's leaving the exact same property to his son. You can tell the question's coming. Who gets the property when Gary Blue passes away? And I hope to see all of you get this one correct. Oh, no. I keep trying to prove my teaching. 91% of you are right. I think the other person was just being cute. Because you see, once you file a beneficiary deed, it is a contract. And you know Matt's telling Linda, well, Dad wanted me to have it because he wrote the will later. Well, sorry. What we've got is poor old Matt, and he's singing the blues because he didn't get the property. Can you imagine Thanksgiving or Christmas time with this family? On the other hand, maybe Gary redid his example of the beneficiary deed and named the Bozeman Community Foundation. And then we would have both Matt and Linda singing the blues because neither one of them would have received it. So keep this in mind. You cannot undo a beneficiary deed with a will. It doesn't mean regardless of when it was written. It could be written earlier or later than the filing of the beneficiary deed, but it's not going to apply. So if you did a beneficiary deed and you don't like it anymore, you need to file a revocation of that particular one. Well, the observation from my lady slipper is that time has slipped by, and it's probably about time to wrap it up, but Joel is indicating we've got some questions, and I want to make sure that I leave time for that. But I hope I did steer you towards an awareness of Montana's plan for the transfer of your property and some of these ownership issues. And I hope I steered you to some of the estate planning tools, like a payable on death designation, transfer on death, and a beneficiary deed. And if you don't have a memory like this elephant's head, we've got 41, yep, count them, 41 different topics on estate planning that you can get through our website. Just click on estate planning publications. And don't forget, those are also available from your local MSU County Extension
agent. Yeah, we do have a question, and I'm actually going to ask it to you
okay,
while we're
Joel,
doing a little bit of an evaluation here. So the question was kind of a general thing about if you're thinking about going to an attorney to get help writing a will, is there a checklist, or what documents should you have so that assumably you can pay the attorney less money and still get a quality will drafted?
Oh, excellent question, because we have a Mont guide that we're just finishing up revising that has the checklist in there. It's called estate planning. Oh my goodness. Anyway, getting started. That's what it is. Estate planning, getting started. And it has the checklist for the attorney. Because, I mean, there's no sense having an appointment with the attorney, go in, and then he tells you, I need this, this, and this, and you're paying for that time. You can have all that information already gathered, and you would have read our estate planning Mont guides, and therefore you would be more informed, and you don't have to pay him $300 or her $300 an hour to educate you. You can get right down to the brass tacks of your family situation.
So if you have more questions, please send those in. Let me just do a quick reminder before we get to the rest of the questions. So 2 weeks from today will be our next session, and that will be Who Gets Grandma's Yellow Pie Plate in Idaho with Karen Ritchell. And then 3 weeks from today, we'll be working with investment professionals, and that will be Lyle Hansen out of the University of Idaho. We'll also do that. Now, back to our questions. We've got a couple more in. Can you have a payable on death on a Montana medical care savings account?
Yes, you can. And that's a great thing. The legislature did not pass that originally. That came about in the next session. I hear rumor that in this session they're trying to raise the amount from $3,000 to $6,000. But that didn't get to first base last time, and I'm kind of afraid it won't happen again this time. But yes, you can do a POD on your MSA, and then if they're in Montana, the kids get to use the MSA as their own MSA, and it won't be income taxable.
Right. And Marcia, could you repeat where the 41 estate planning topics are available at?
Okay, these are, oops. There it is. And quite frankly, if you just Google Montana State University estate planning, and then you're going to get a whole lot of estate planning course type stuff. But this is the easiest address to use, rather than using the search engine, because then you're going to go through. And with this one, we've got webinars, we've got PowerPoint presentations that you can use just to refresh your own mind, and a wealth of information on the area of estate planning. And I hear that we do have some folks from a community foundation that are listening in today. And I want to let them know that Tyler Wiltgen and myself are working on a Montana Endowment Tax Credit Mont Guide. We find that there are lots of questions in that area. And now that people don't have to worry about the inheritance tax or the federal estate tax unless they have $5,490,000, what they're doing is if they leave this property after they die, they're missing out on some income tax benefits. So I have a fun presentation showing Champ on how you could use the Montana Endowment Tax Credit.
We do have another
so
question
sometime you might want to see that one.
Using TODs and PODs, why do you need a will?
Oh, that is a good question, and let me tell you why. In Montana, there is a thing that's called a separate listing of tangible personal property. And through the years, I've discovered families often have more fights over these kinds of things. And here I'm talking about grandpa's guns, maybe mom's quilt, and some of those. There's things that don't have a title. So our legislature came through again. They said, in your will, if you say, I have a separate listing of tangible personal property, then that has the weight of law. And that means your personal representative can use that list to go to people and say, okay, Carrie, you were not supposed to have that quilt. It was supposed to go to Susan. And that then makes it a lot easier for your personal representative to do things. It's a lot more tough when you get the three daughters together and they all go in there and everybody wants the same thing. And if you're not careful, you wind up with hard feelings. And at least this way, I tell the parents, let them be mad at you. You've got the list, and they're going to honor your wishes. So that's why I'd still have that will, if nothing else, for the separate listing. And the other thing, hey, those of you with minor children, you need to name a guardian, and you also need to nominate a conservator. The guardian takes care of the kid. The conservator is the one that handles the money. And you could have one person do both functions, or you could have two different people depending on what it is that you prefer. So, yep, you need a will. I have a will.
All right. Well, thank you.
Even though I take advantage of the other things
just a
as
couple
well.
quick reminders here. Well, first of all, thank you to Marcia for presenting this week as well as last week. And if any of you didn't catch this, all these wildflower pictures we saw today were Marcia's personal photographs. So sharing those is another skill you have in addition to your estate planning knowledge. So thank you for presenting today.
Oh, Joel, can I get a word in edgewise here? I must confess, you'll probably notice on some of those there was a GAP. That's Gary, my hubby. And we have what we call best of show. So we both put them up on the computer. And if his wins, I use it. If mine wins, I use it. So I don't want you to think that I didn't.
And while we were asking that, we've got a couple more questions come in. So maybe before we wrap up, let's address those two quickly here. So does this list have to be with the will?
Well, it is a separate listing, and I would recommend that it be with the will wherever the will is stored, whether that be a safe deposit box, etc. Because when you do the separate list, what you're going to do is sign it. You're also going to date it. And boy, in this day and age with our computers and files that we can save, that makes it so easy to update it. I was driving down the road and realized that I had not put in the grandfather clock that my mom and dad brought all the way from Kansas and finished up in Montana. So it was very easy to go in,
and our last one
sign
here is
a new
where
one, and
can
print
you
it
find
out.
the forms to name a designated beneficiary?
Those forms are with the financial institutions. So for example, you go to your bank and you say, hey, I want to put a POD on my savings account, and they'll whip out the form that they use. Same way, you want to do that with your some of your stocks. Some of those are on the web. If you can't find them, contact the company and say you want a new beneficiary designation form. And if you have a stockbroker, he or she can track that down for you as well. So it's not a specific form that a business would have or on the web would have, like they do with wills. It's one that's particular to the financial institution where your account is located.
And how about a beneficiary
Although
deed
Montana has a uniform form. Oh, that one. In our Mont guides, we have one that is called a beneficiary deed. And we have a form for that was statutory, and we can do that when, forms are in there. We also have at the website there for the estate planning an example that you could download and then add your more information. But be sure to read the Mont Guide, because there's a lot of considerations of what you put into that. Like, do you want the people to take it as tenants in common or as joint tenancy? And do you have a successor beneficiary in there? So it's not necessarily a do-it-yourself approach.
The questions now, and thank you all for submitting questions today. With that, I think we'll go ahead and wrap up for today. We will return 2 weeks from today, so if you'd like to join us, we'd be happy to see you in 2 weeks. Otherwise, I hope you learned something new today, and I hope you all have a great day, and thank you to Marcia.